This is Kansas City's second jury improvement lunch. These are lunches that we have been putting on around the country over the last 5 years. This is the 37th such lunch we have had, where we invite trial lawyers, trial judges, and discharged jurors to come share with us ways in which we can improve the quality of trial by jury in this country. The Civil Jury Project, of which I'm the executive director, was started 5 years ago as the nation's, and we still are the nation's, only academic center that is asking the questions, why are jury trials, civil jury trials, disappearing? Is it something we should be concerned of? And if so, what can be done about it? There is no question that jury trials are disappearing. If you look at this slide, it shows that since 1962, the number of trials on the average by federal judges in this country has dropped from 10 to 2. You will see with the red line is jury trials, the blue line is bench trials. Something that I did not know until we began studying this was that bench trials are disappearing even faster than jury trials. So the idea that the reason the jury trials are disappearing is that parties are opting for bench trials because they are quicker or cheaper or more reliable is simply not true. They are not turning to trial judges sitting without a jury to resolve their dispute. They're either not getting them resolved or having them resolved outside of the public courtroom. Both the decline in jury trials and the decline in trials in general should be something I think we are concerned about. And if you look just at the figures for your two federal districts that are here, you will see that the Western District of Missouri tried a little above the average at 2.3 jury trials, and the District of Kansas was under the average at 1.7 jury trials, which means that a lot of federal judges in this country aren't trying cases at all because these are averages. If you say, well, the reason the total number of trials is declining is because the total number of cases in court is declining. Well, that's rebutted because by these figures, which show the percentage of cases that get resolved by trial by jury or trial by a bench trial. And you can see those numbers are way down from 1962 too. The situation in state courts are not much better. You can see the trend line for jury trials in Missouri state courts, the circuit courts, and in Kansas courts, the percentage of trial by jury, the percentage of cases is down too. The statistics are terrible. Now, should we be concerned about this? Well, as we are speaking now, for the first time in my lifetime, the Association of Federal Judges, Federal Judge Association, is having an emergency meeting in Washington, D.C. This is an association of current and former federal judges to deal with the issue of the recent attacks by politicians on trial judges, primarily in the criminal area, their sentencing. We have seen it happen, and never before has the independence of the judiciary been under such incredible attack that warrants this emergency meeting of the Federal Judges Association. The reason our founders thought that a jury trial was so important is that the king had denied them the right to trial by jury, and that's mentioned as one of the reasons for declaring independence. It's on the first page of the Declaration of Independence. Kings denied us the right to trial by jury. And the people who wrote the Constitution realized that the ultimate protection for the average citizen from an overreaching government or from judges who were appointed on the basis of some kind of litmus test or loyalty oath to the king. The only way to protect the average citizen was by a trial by jury. 12 people, cross-section of the community, gathered off the street. They couldn't be intimidated. They couldn't be bribed. You didn't know who they were in advance. And our founding fathers, who put that in the Seventh Amendment, and the jury trial is the only right that gets mentioned 5 times in our founding documents, did it because there were no illusions. They knew jury trials would be more expensive, take more time. Juries would be more susceptible to eloquent advocacy. Still, they wanted jury trials as the ultimate check on judicial abuse in this country. And when you think that 95% of the trials in this country are in state court where judges get elected, many of on partisan basis, it becomes even more important that litigants, when they are appearing in our courts, have a right to a jury who is not beholden to anyone for anything. They come, they serve once, frequently only once in a lifetime, and they then do the best they can. In any event, what we have done over the last 5 years, the Civil Jury Project, is first to enlist the help of state and federal judges. We now have over 360 state and federal judges across the country as judicial advisors. We have 70 academic advisors, and we have 42 jury consultant advisors. We seek input from our advisors on all sorts of subjects. We've done a lot of empirical research. We have, I think what we recognized all along, we certainly recognized it from the very beginning, was that one of the reasons that trials are disappearing is that there are a lot of people taking the bench that have never tried a case before. And if you go before a judge who doesn't have experience trying a jury case, either as a judge or as a trial lawyer, what is the likelihood that that judge is going to find there are no factual issues to be decided by a jury, and therefore he and his law clerks or she and her law clerks can resolve the matter on the pleadings? The likelihood's high. No one wants to embarrass themselves doing something that they've never done before. So we have focused on trying to educate judges. We have now had over 250 state and federal judges come for workshops, full-day workshops at our expense at NYU Law School. We have 2 coming up next month on the 19th for state court judges and the 20th for federal court judges. And if any of you in here are judges who I do not know, and this is your first experience with the Civil Jury Project, and you're interested in attending one of these seminars or becoming a judicial advisor, make yourself known to me or Michael Pressman, our research fellow, who is here with us today. One of the things we have done is promote jury innovations in jury trials. And that's what we talk about a lot at these workshops. How can we make it so that jurors are perceived to have all the tools that arbitrators in an arbitration or judges in a bench trial have to decide the case? Things like get the instructions at the beginning of the case rather than at the end of the case. Everyone gets a copy of the instructions, the right to discuss the evidence with your fellow jurors before final deliberations, the right to ask questions. There are a whole series of things that we can do to give jurors more power, better education, and at least create the perception among those repeat users of the legal system, frequently big companies and their in-house counsel, that juries can get it right because we've given them all the tools to get it right. So these innovations are some of the things we are doing. We publish a monthly newsletter. You came today, you gave us your email, so you'll be on the mailing list for our monthly newsletter, and they are quite informative on what's going on in the jury trial world. We have a website this is primarily for judges and lawyers, that has all of our programs. This program is being videotaped. It will go up on this website in the next couple of days. You can see each of our 37 lunches. A video is posted on this website. We have a separate website that is to be visited, hopefully, by people who have recently served on a jury or people who have been summoned to serve on a jury, hopefully not by people who are currently serving on a jury, because if they click on that portal, which is in the middle, they are said, you shouldn't be here. You know, the judge told you not to be here. So wait until you finish your service and then come back. But if most of the people come here who have received a jury summons and they are coming looking for a way to get out of jury duty. And if you go on this site, wethejury.com, and click there, you will see many testimonials that we have gathered from jurors. When we go to these luncheons, we ask some of the jurors to stay around. We take short videos. And basically the message from these former jurors is don't throw away the summons. You are about to have one of the best experiences of your life. And they talk about their experience, all of which seem to be favorable. And then if they have served on a jury before, they are given a questionnaire to answer. And we have had thousands of questionnaires filled out. Both the courts give them questionnaires in their courtroom at the end of a trial, and they send them to this website to fill out the questionnaire. So we have learned a lot about what jurors want, because until we got into existence 5 years ago, no one was even asking the question, what jurors want and how can we make things better for jurors? You have found on your table, one of the things I gave you on the table, that you would be doing me a favor and us a favor if you take that with you. There's a sheet called The Reasons Why Jury Trials Are Disappearing. And on the left side are things that it's hard to do anything about without a new law being passed or new rules of procedure being passed. But on the right side are 7 or 8 reasons that we can do something about. We can reduce the expense. We can make sure that young advocates, like many of you in this room, are trained to try jury cases. We can make sure that judges give jurors the tools which they need to provide the perception that they are as capable as judges or arbitrators of getting it right. So those are what we want to focus on. And if you can think of others, send me an email. Our email is on there. And if you think we've got some on the wrong side of the page, let us know about that. We will now kick off the program. We're very lucky today we have been looking around the country for trials that take place which get settled after the jury returns a verdict, so that the jurors are free to talk. The judge is free to talk about the case. There's not going to be any post-trial motions, nothing about jury misbehavior. And the lawyers who are in the case can talk about it too. They can explain why they did certain things. So it makes we've been going around the country now for 4 or 5 years looking for cases like that. The first one we found, we had a program put together quickly on December 11th. It was before Judge Tom Martin. He tried a big case, lasted 3 weeks, in Wichita in federal court. And we had 4 or 5 of his jurors attend one of these with the lawyers, all the lawyers involved essentially on a panel discussion. And Judge Martin was in the audience. So he's agreed. Tom is one of our first judicial advisors. He's agreed to come today and moderate the discussion. With him as a moderator is one of our jury consultant advisors, Amy Kleinhans, from Jury Sync, a jury consulting firm. And the two of them are going to be doing the moderating, which means I can just sit around and enjoy myself today without having to ask the jurors questions. We have also present Why is this all happening in Kansas? I don't know, but something about the water in Kansas and jury trials is called, huh? Whatever, Missouri, whatever is happening. So before this program, as this program was getting underway, we got a call from Judge Torrance, who is also one of our early judicial advisors and has been to one of the workshops at NYU. And he said, I just finished 2 cases that I think fit the bill. They both settled. And he extended the invitation to some of his jurors, and 4 of them are here today. So I'm going to begin now showing you a video that illustrates the problems we are dealing with. As I do that, will Juror Case, Colhar, Decker, Hook come forward. Judge Torrance, you have a seat. And the 2 lawyers here, is Stephen Williams here? Yes, you come forward. And these lawyers are great to come forward. I don't know whether they won or lost, but I think there are actually one of them here. Is it Williams here or is it Slough? One of you guys, come forward, please. One of you guys was a loser. And if a guy comes forward, if a trial lawyer comes forward in a case that they lost and is willing to talk about it, that's probably the most educational experience another trial lawyer can get. So thank you both for coming forward. And here is is the volume up? Michael?
Thank you for coming. Now, I realize that you were summoned to this class without signing up for it, and you haven't even been told what this class is about. Nevertheless, let me tell you what the rules and procedures are. This course could take a few days or a few weeks. I'm not sure. This course could be taught by 10 or 20 different teachers, and it will involve a subject you know nothing about. In fact, if you knew something about the subject to be taught, you couldn't take the class. Each teacher will give you relevant information about the subject, information you'll need for the final exam. However, I will not tell you what is important and what isn't. Not only must you determine what is consequential or not, you must also figure out which teachers have told you the truth. And you can't take notes to remind yourself of what you've heard or what you thought was important. Also, you may not ask your teachers any questions, no matter how confusing the lectures are. Nor are you allowed to talk to your fellow students about anything the teachers have said, even though this is normally how you go through a college course, or life for that matter. And while it might be helpful to have a notebook for notes, course materials, or even an idea of what the final exam might be about, it ain't gonna happen. However, we will let you look at some of the materials while one of the teachers is lecturing on another important aspect of the course. Now, I won't be telling you what is important in this course or what the rules are for the final exam until all the teachers have given their lectures. When I do explain the final exam, I'll spend only 15 or 20 minutes on it, and I will probably use unfamiliar or technical terms that I will not explain. The final will involve only 1 or 2 questions, and you will have 1 sheet of paper to write the answer on. You can then discuss the course with each other, but bear in mind, you will all have to agree on the same answer to receive credit for the course. You will also be locked in this room until you reach agreement. Oh, and one more thing. Depending on your answer, someone you don't even know will either win or lose. Any questions? Good. Let's begin. This will be a rewarding experience for all of us.
All right. That's it. And Judge Martin, will you begin with the panel and take it? Amy, go ahead, y'all. Work your magic.
This is working. Todd Thompson, who actually participated in a trial that we did about, 2 years ago, Todd? Maybe longer than that. Just seems like yesterday to me, is with us today, and I hope that you'll chime in at times. My name is Tom Martin. Before I get started, there are a couple of things I'd like to tell you about. I don't know how many of you know Steve Sussman, either personally or by reputation, but Steve not only founded but funded this project for the first several years. He is a graduate of Yale, University of Texas Law School. Graduated first in his class with highest grade point average ever at UT Law School. Clerked on the Fifth Circuit for a judge, and then clerked for Justice Hugo Black at the U.S. Supreme Court before returning to his home state of Texas and practicing with Fulbright and Jaworski for a number of years, taught and then set up his own practice, and since has not only been hugely successful in very complex litigation, securities litigation, antitrust litigation, but really has been a leader in this whole area of preserving jury trials for decades. And this is a labor of love for Steve, and we all owe him, frankly, a huge debt of gratitude. I'd read about him years and years ago, but actually met him about 3.5, 4 years ago at a meeting back in Washington, D.C. And we were putting together a conference here called the Kansas Legal Revitalization Conference at the time. And Steve immediately agreed to come out and present. And it's been a wonderful friendship that's developed over the years. And Steve, I'm grateful to have had the opportunity. And Michael Pressman, who is here, not only has a law degree, but also a PhD. He clerked for Judge Bacharach, as I recall, in the 10th Circuit. So he does have some ties to our part of the country as well, before signing on as a research fellow with the Civil Jury Project. And Michael's right in the middle of all of these luncheons and every project. And Michael, thank you so much for what you do. How many of you attending here have tried 5 jury trials in the last 2 years? A couple of you. And how many of you folks who are jurors here today, and I'm sorry I'm not standing in front of you, I probably ought to go to the back of the room. How many of you had been on juries before? Okay, one of you. And these were civil trials that you recently were part of, or one of them anyway. And what was the other jury trial? Was it a civil or a criminal case? So they've both been civil. What was your greatest frustration as jurors? And I'd love to hear from all of you with respect to how the trial was handled. And by that, I'm not talking about judges' rulings but I am interested in really what would have made the case easier for you to understand from the outset through the end. And we can start anywhere if you'd like. Ms. Decker? Okay, let's talk to the crowd too.
The comment that was made earlier about it, we could talk about the case as it was going along instead of waiting until the very end. I think would have been helpful because you have ideas in your head.
Oh, the mics close.
Things in your mind that you want to talk about. Not sure.
This one works.
Like it was said before, about talking about the case as it was going along, the information that we got as the trial was going along. If we could have talked about it and not waited till the very end to discuss any facts, I think that would have been helpful while it's fresh in your mind. Just something I noticed. I mean,
I agree. I also believe we didn't know until till closing arguments what was being asked for. I mean, we knew it was compensation, but how much? I mean, I had in my mind a small amount, but the amount was greater than I thought. So just going into knowing, okay, it's compensation, but what amount, even if it's just a range, giving us a range of what we're looking at. And as she said as well, being able to discuss the trial with the other jurors, as we're going through the process. We're together for 4 days, most of our waking time together, and not able to talk about all of this evidence, everything that's being presented before us. So I think that was kind of, I don't know if it was a frustration, but just kind of an annoyance. Right. So.
Mr. Houck, how about you? If you pull that mic up to you.
Sure. One aspect of the case that I sat on, both the plaintiff and defense, of course, had what we would consider just large amounts of evidence. I mean, they were both like 8-inch binders with hundreds and hundreds of documents. And even though I took several pages of notes, as they were being submitted, stuff like that, I didn't write a single item number that was submitted. So when we got in, then we knew that we had access to those if we wanted to review further or anything like that. I had the description of everything, but not we need to see number 25 from the plaintiff or whatever that case. So just, that would have assisted. I think one of us of the 12 actually wrote down the item number for every single one. But something like that would have helped tremendously to speed up that process. So.
Ms. Case?
I agree with these lovely women right next to me. I served with them, and it was, for me, it's more difficult to keep everything fresh in my mind after the fact because, like we said, we were there for 4 days. I forget things as it is as a daily process. I write everything down, thankfully, but that doesn't cover everything. And I know I forget things very easily, so if I'm 3 days in, I forget details that were presented on the first day. So it's better for me to talk about things or even write them down and be like, oh yeah, I forgot about that, or what about this, or something. Just be able to just not even come to a decision. It's just be able to talk to each other about the evidence that has been presented or anything along the lines of that, of just what we have in front of us at that point in time.
Judge, how do you typically handle your trials? What comes first and what's the order of events?
It's the standard method, I guess you'd call it. It's
Jury selection
We go through jury
first?
selection, get them sworn, do opening statements, and then proceed with plaintiff's case, defendant's case, and closings.
Okay.
And the instructions that are read by the court precede the closing arguments in state court, Missouri.
And have you ever tried a different or a variation on that order?
Well, I've tried to sell lawyers a few times on using early case summaries, and nobody wants to do it, And does anybody here know MAI E100? Has anybody ever seen it or read it?
Yeah.
Keith, yeah? Yeah, it's actually not mandatory, but the Supreme Court of Missouri has given us trial judges the option to use an early case summary instruction, which would be a very concise summary of the claim, the defenses, a little bit about rules, and it's read before jury selection even begins.
And is this something that the judge does then, the early case summary? The parties have agreed to it, or at least have provided to you?
I think it's unclear about whether you could do it on your own. I'd like to think you could. I think you can, just based upon the pleadings and conversations, summarize the claims, summarize the defenses, and read it. Of course, I've always invited, when I've tried to use it, I've tried to invite people to, put their own summaries in there.
Counsel, could you give us just a brief summary from your perspective of what your cases were about? I think that would help all of us get a little context here.
I tried our case with Steve Millen, for the other plaintiff's lawyer. It's too bad he's not here because he's the guy with the gift of gab, as you probably know. But our case was a standard personal injury case, intersection collision with a what we said with a head injury component, and we claimed a brain injury. The other side defended that there was no brain injury. It was essentially a case about damages.
Did you have medical experts?
Yeah, we did. We sure did. And mainly we had neuropsychology,
Right.
which I don't know. I just think it might have been a little difficult for people to understand the science of that. It may not have been explained in a way that was adequate. I don't know that. I know that I know we got a judgment, and I know, of course, we would have liked more, but we were happy with what the jury did.
Now, help me. Your last name is pronounced how?
Slough.
Slough.
Yes, sir.
Just like plow, but okay.
I answered anything close to that.
Okay. Thank you very kindly. Mr. Williams, what was your case about?
I tried my case in front of Judge Torrance. It was a discrimination retaliation case. I was the defendant and the loser, as the gentleman stated prior. Pretty straightforward case. There was a gentleman under the age of 40 who thought he had a good faith claim for discrimination, learned he didn't, but then there still was a retaliation claim. And so those are kind of the basics of the case. There wasn't anything really out of the ordinary about the case. The one thing that I found interesting and that I hadn't experienced before was that at the end of the trial, many other folks on the jury shook our corporate rep's hand, told him they appreciated the work that he did. They weren't upset with him or didn't have any bad feelings about him, but they still returned the judgment against us. I hadn't experienced that before, where they were like, we appreciate the work you do. You did a great job. We're better off for the work you do. However,
Bring your checkbook.
yeah, in short. And so that was unique.
Well, I think most of us who have tried more than 3 cases have had that experience at one time or another. Amy, anything you want to?
Well, I'm interested for those of you that were on Mr. Slough's case. He said that he thought it might have been that the medical experts were potentially confusing. How did you feel? Were you able to understand what they were saying? Was there anything that might have helped you better understand? And how did that help you with your decision?
Pointed out that there was never a medical doctor that came forward. So I think that kind of put a little doubt in our head with the neuroscience. I don't know if they're a physician or what they're called, but yeah, that was, I guess, kind of didn't really stick with us, I guess, because no medical doctor came forward to identify that she had a head injury. So
I also agree. I understood what the what were they, neuropsychologists? Yeah. I understood what they were saying, but I think probably where maybe I would have felt a little bit different if it was a medical doctor is hearing that they were paid character witnesses. So that piece of it just kind of.
Would have awarded more money to the plaintiff if there was a medical doctor who testified to the injuries?
I don't think the evidence was there.
I mean, I don't know.
Yeah, I mean, even if there was a medical doctor, I just don't feel like I would have, the evidence wasn't there as far as there was the accident, there was a brain injury, but the brain injury wasn't discovered until way after the fact. So, if the pieces could have come together a little bit better, then.
If there are questions from the group, and I hope you will all ask questions at some point, I'll repeat the questions so we get a good recording of it and we know what the question is. Were you two the only folks that were on the personal injury or Ms. case? Were you on that one too? What's your thought about that?
Which one?
Well, the last question was, do you think the jury would have awarded more damages if a medical doctor had testified?
For me, I don't think I would have, just because I had I knew the concept. I kind of roughly know what everything is about already, but it was more of on the side of the plaintiff. It was more a personal responsibility for me personally was what was holding me back a lot more.
Yeah. Go right ahead.
By personal responsibility, do you mean like delay in gaps of treatment, or what specifically are you referring to with personal responsibility?
The
Yes.
question was whether the issue was the delay or the gaps in treatment as opposed to something else.
Yes, and the not willingness to seek other alternatives. I mean, obviously, with the case that was there, she did try one thing, but then she stopped going. And then after that, there was, she was saying that she was still having the issues and along the lines of that, but she was unwilling to try medication. She was unwilling, and I know medication is not for everybody, but at what point do you want to try everything and see if it works for you? Because I know some medication doesn't work for some people, some do, and you just have to find that right balance.
Mr. Houck, were you on the other jury?
Yes.
And what was your perception of the case as you went through your responsibilities as a juror?
So the way I don't want to say I enjoyed it because, who says they enjoy jury duty, but I definitely came away with a different perspective and appreciation for the process. I can't speak to the ladies to my right as their background or their experience or the things that they do, but I was probably more well prepared to serve on a case like this just because I don't hold any HR certifications, I don't hold a legal degree, anything like that, but through various positions through my my work, I've been involved in different things like that. I've taught Code for the Road and Code of Business Conduct to new supervisors in our company. I've taught Title VII. I've taught, how to reply, how to conduct injury and accident investigations. So I've been involved in processes like this. So when it came time to look at the evidence and as it was shown to the juries, that I probably had a much different perspective because I'm looking at, well, you've made your claim and this is how you defended it. Now, where was your evidence to defend it? And in many cases, unfortunately, I didn't perceive it was there. And from Mr. Williams' response, majority of us didn't perceive that it was there in order to meet some of the claims and things like that. So, like I said, I would never say I enjoyed it, but definitely if I was called again, I would definitely look at it with through a different lens. And one thing while that's on my mind, because I'll probably forget, but it got mentioned at the very beginning about the roles and responsibilities whenever you get that summons and how you are impacted by it. I think it would be, I don't know if there's a way to do it, but very good to let the juror know what their rights are. I'm very lucky that, again, with my company, when I told them I'm a salaried employee, my pay didn't change. They knew it. They were like, well, just let us know when you're done, keep us updated. There was no pressure from my employer at all. But even through the jury selection process for that case, I mean, you have some people in tears. I can't afford to miss a day's pay, which in Missouri, I think if I remember right, it's not mandatory that they get paid for jury duty. Correct. And Judge Torrance, was, very empathetic to those and made that known. But, so at least when they get that summons, whenever they tell their boss, they're getting that pushback immediately. I need you here. You can't, I can't afford to lose you, or you won't get paid for it, whatever the case may be. So if they knew their rights up front at the beginning, they might feel a little bit better about that process. So sorry, I know that's off track, but I knew I'd forget it, so I wanted to talk about it.
Well, it's really not, though. Judge Torrance, do they have a procedure here in Missouri where if somebody really is a hardship case, they can notify the court ahead of time and seek to be excused rather than having to show up that morning and go through the process?
Yeah, there's a process for it, but it typically has to be age or medical problem related.
Right.
Employment issues, self-employment issues aren't going to get you a pass over the phone.
Yeah.
I always tell everybody on Monday before I cut them loose, get involved in the political system, write your legislative. Missouri is one of 4 states that don't require employers to pay their employees when they're on jury duty. And so, unless you have a union contract or a particularly good benefit package at work, you probably aren't getting paid when you're on jury duty. And it's a crime. It needs to be fixed.
And these
Up until this past year, in Jackson County, we were paying jurors $6 a day. Which is the statutory minimum that the state requires. Different counties do their jury compensation in different ways. But we worked into our county's budget this past year the ability to get it up to, I think it's 18 now, right? You guys would know that handsome check.
Oh, yeah.
That generous check, which is still absurd. I mean, $18 a day is stupid. It's insulting, but that's where we're at. Yeah.
How
We're
long
working
were
on it.
these trials, Judge?
I'm sorry?
How long were these trials?
I think they were both 4 days, I want to say. Fred, yours was 4. Yeah, they were both 4 days.
All right.
Which is about an average civil jury trial in Jackson County.
And that's from reporting in and going through jury selection until the verdict is returned?
Right.
And were you able to advise the jurors ahead of time how long the case was going to be or when it would end?
I tried to. I think I did.
Yeah.
You said you thought 3, and it was 4, so.
Yeah.
You told us roughly it would be about 4 days, including that day that we were there. Monday.
You try to discern that from the lawyers, talking to them at the pretrial, and just to let everybody know, because it's hard to evaluate hardships if you don't know how long you're going to be there.
And what is your trial schedule generally? What time do you start in the morning, stop in the afternoon, and what kind of recesses do you take?
Yeah, 9 to noon, 1 mid-morning break, usually 15 minutes or so, and then 1 or 1:15, 1:30 sometimes, depending, because I'm sometimes got to squeeze stuff in.
Sure.
You know how it is. And then we usually try to go to 5 or so with a mid-afternoon, break.
Oh, I'm sorry.
I have a question. Mr. Huck, I have a question for you and Mr. Williams. First, during voir dire, were you ever asked any questions about the sum and substance of your experience with HR?
It was asked specifically, one question in particular was anything with terminations, and which I did speak up and said that I had been involved when I was a safety manager with, we're a unionized company, and so I did have experience with the National Master Freight Agreement, and I had taken part in terminations from a contractual standpoint. And in that case, I think specifically it was a drug and alcohol abuse. I can't remember if I mentioned that, but that's what it was. But no, because I was thinking about it specifically as I was sitting in the jury box, and it was specific to certifications or employed in the HR department, which I had not been. It was just something that I had, again, through 16 years with the company, been involved in different things, but never in an actual capacity.
And was there any like catch-all question like, would you like to share something? We didn't ask you the right question, anything like that during voir dire that you would have volunteered?
No, not that, because I spoke up, I think 3 times, if I knew anybody for it been a part of a termination or anything like that, but and I think there was something else, but I mean, I was just really thinking about it, but I was like, not to what the question that was asked, no.
And so, Mr. Williams, were you surprised just to hear from Mr. Huck his level of experience on an employment case? I mean, I was just surprised that you'd even make a panel, given. So I was just curious about that.
To some extent, yes. I knew we had, I think, a couple of folks who had some HR experience, maybe not, there wasn't their role in their companies, but they had some knowledge of it. But from the defense standpoint, obviously, I'd be happy to have folks like Mr. Huck on my trial. And then secondly, from the panel, I knew plaintiff's counsel had some tough choices to make. And so for that reason, I'm not completely surprised because they had some other folks that I was pretty confident they might strike.
Amy?
Were there any issues in the employment case that you saw that you found confusing that would have been helpful to have explained better?
I don't think so. None that I can remember, but similar, you just so many times during the, whenever something was discussed or brought up or evidence, right then and there, you're like, man, I wish I could ask a question or, get some further detail about it. But not from my standpoint, nothing where I was like, I just don't understand that.
You
No.
noted on your questionnaire that you felt like jurors were on somewhat of different pages, or it would have been helpful if they'd all been on the same page. Can you elaborate on that and how you felt like you were on different pages?
I think it was, again, just my perspective and how I was looking at it in terms of was a policy violated? Did they actively work against something that they had enacted within that district or whatever the case was? And I think some really struggled to grasp that in terms of, and I don't know if we can go into any specifics, but it wasn't a corporation or a company per se, but just
There's no restrictions. You can
it was a school district, and so I think they had a lot of questions about how the school district would operate versus a company, and I think that's where there was some confusion about what would apply. Well, would this apply the same as it would to a company as it does to the school district? And several had some questions that didn't fully understand the policies that
Were you
like
able
that.
to ask the court any questions?
I think. I was going to say somebody requested one or they wanted to, and you sent your response back.
when you were deliberating.
Yeah, deliberating.
She
yeah.
means during the trial.
Oh no, we didn't ask.
But you were during deliberation, you were able to.
Oh, I can't remember what it was or whatever it was. You politely said, "I'm sorry, but I cannot answer
Yeah.
this." So, yeah.
Or please reread
Yeah,
instruction number 13.
exactly.
Yeah.
Thank you. I'd be interested to hear from the 4 jurors about the comment about not being allowed to talk to each other about the case as it's going on. What would you find helpful about that? How would you think that would have made life easier for you if you'd been able to talk about it as it went?
I think it would have made it a little bit easier when it came around to deliberation, if we were able to, kind of talk amongst each other during the week of the evidence that we had heard. I felt like once we got to deliberation, it was like we all unloaded on each other just because we weren't able to talk about it all week.
Overload.
Yeah.
Did you feel like you had any idea about how the rest of you were thinking about the case?
With all 12 of us, we were all over the board. We were literally from for compensation, we were zeroed up to like up the full amount of, what was it, $500,000? 350. Yeah, we were like, everybody was all over the board. And that's where it's really nice to see where everybody stands about that, because you get to see everybody comes from a different background, and we all get to realize, what are you thinking? Why, what is your thinking behind this? And I know for me, I was on the lower end because I am one that I take personal responsibility if something was to happen. But then there are other people that are like, well, you know, how would you say that?
You know, I think it's most important
Yeah.
that everybody here, from the jurors and from the judge and the lawyers, but I do want to take 2 minutes to talk about some things that we have done. First of all, I have the lawyers right out of the chute make opening statements to the entire veneer panel. So everybody who comes in for jury duty hears both sides, their full opening arguments. And sometimes that's 45 minutes, sometimes it's 2 hours. But then everybody has an idea what the case is about. They're thinking about it. They begin to get a little engaged. Memories are triggered that wouldn't otherwise be. I remember Uncle Joe had a situation like that, or my sister. We go through voir dire. And by the way, it shortens voir dire. And also, lawyers aren't trying to sell their cases with the questions they ask. And it really allows you, I think, to find out who these people are, what they're interested in, how they're thinking about things, and about their experiences. Once we get the jury picked, the next thing I do is to give the jury a full set of instructions. And I mean, they are essentially the final set. We may alter some as we go along through the trial, but I tell them that that's a possibility. So they all know what the law is right up front as well. And they each get a copy, and they can take notes on their copies as they go along, but they're listening for the elements of the case and what the proof is. I let them ask questions during the trial. They submit them in writing. I review them with the lawyers. I've had precious few that have not been good questions. Once in a while, they'll say, how much insurance does somebody have, or something like that. And of course, you say that's not an issue here, and so we won't get into it. But I let them discuss the case every time. And I've gone back to 12-person juries in civil cases in every case. And anytime all 12 are together and can participate, I let them talk about the case. And then there are a few other things. If you're going to have a witness offering complex testimony, I let the presenting lawyer say, this is what we're hoping to establish with this witness. Or afterwards to say, this is what we think we've established with this witness. And the other side says, well, we think we've chipped away at this, and this. And then at the end of the case, the only thing that I read before closings are any modifications to the instructions. We take their old ones out and put the new ones in. And we have not had a single request for a readback in a trial since I've allowed the jurors to discuss the case during the trial. And to talk to them afterwards, they said having the instructions, first of all, they said hearing about what the case was about was terrific at the outset. And by the way, the people who are never called up to the box pay a lot more attention to voir dire. And when they leave, they're not irritated at having spent a morning or whatever sitting there just listening to questions. They feel they've participated in the case, and they can go to the office or go home and say, well, you know, I got called in. And probably the best part of the whole aspect of openings first is that people don't dread jury duty the next time they get it. We in the federal system are lucky Because when I started doing this, as Todd can attest, I sent a memo out to all the lawyers and said, everybody who's got a civil case sent in front of me, this is the procedure we're going to use. It's not a request for criticism or critique. There will be plenty of time for that, but this is how we're going to do it. Because, you know, that's the only way it happens. You're all lawyers, so you know this. We are the last people in the world who want to try something different. You know, I don't know why we're fearful of it, but one of the beautiful things when I always wanted to do things different when I was practicing too. But, you know, as a judge, you're more interested in it being a good process than the outcome of the case. And part of it being the best process it can be is for the jury to have a complete understanding of the case they're deciding. And of course, as lawyers, there are some things you want to emphasize, and there are some things you'd rather the jury didn't think about, and that's understandable. But if we are at a point where we're trying a case and you think you've got a good case, you've got one that you can win, we shouldn't fear the jury getting all of the admissible evidence. And to talk to jurors afterwards, and Steve and Michael have both seen the evaluations, and they heard 4 of our jurors at our luncheon in Wichita, and that was after a 3-week trial. Now, it was a 12-year-old oil and gas case, and you know, those are not always the most gripping, scintillating kinds of cases. But every single one of them said they were looking forward to their next opportunity to serve, and they understood what the case was about. And coming out of breaks, they'd have questions written down. We didn't understand this. What date did this occur? Some of them we could answer by stipulation. The lawyers got to clear up the other factual questions with their witnesses while they were there. So it was all about making this case the best, most comprehensible case that we could give to the jury. And
Tom, I just want to add something quickly for your benefit. When we go around and do these things, Michael Pressman, the research fellow, gives me a memo about what is and is not allowed under local rules. Everything we're talking about can be done by agreement. 2 lawyers can agree on it, including allowing the jury to discuss the evidence when they are together in the jury room before they deliberate at the end. And I urge the lawyers to think about agreeing to that, because I think it benefits both sides. And you heard the jurors say how much that would have meant to them to have discussed the case as they went along with each other, not have to wait till final deliberations.
And we do give them an instruction, too, that says you are not to make any final decisions on anything.
But that one, probably the judge cannot order.
Yeah.
Because the rule here in the state, both Kansas and Missouri, is that there are standard instructions you give the jury that they are not to discuss the case until deliberations. And that would have to be changed.
Now, there are a couple of states that actually by statute require the judges. I think Colorado and,
But
maybe
every
Arizona.
other innovation that we are talking about for the Judge Martin trial can be done in your state courts by the judge saying, this is what we're going to do. And it is not reversible error for the judge to make that decision. We're going to allow the jurors to ask questions. I don't care what the lawyer. One of the problems we run into, and why we urge the judges to be innovative in this, is that the judges say, well, I don't want to do anything that I've never done before, and that the lawyers object to it. And so that explains the slow pace of change in a way, because the lawyers don't want to do anything that they've never done before. But all these can be done lawfully. The judge has the power to do it.
Well, Todd, having lived through one of the early ones like this, do you have any, I think you were concerned that one of the jurors made up a mind early, maybe during opening, and wanted to be on the trial. Maybe that wasn't you, but what's your what's your take on some of these things?
We did have someone who made their mind up early. One of the questions that I had after talking to the jurors was the need to appoint a foreman at the beginning to shepherd those conversations. Otherwise, they get a little wild and carried away and no one's in charge. So I would suggest that you ask the foreman be selected at the very beginning if you're going to allow them to, quote, deliberate on an ongoing basis.
Well, that's really an interesting thought. You know, in this 3-week trial that we had, one person just kind of took that on with the agreement and enthusiastic support of everyone else. But that's a terrific suggestion, and I am going to incorporate that. Thank you. Yes.
Do you require that all jurors be present when they discuss the case during the trial?
Yes, everybody has to be there to hear and be able to participate.
And do you instruct them that if two go to lunch together, they're not to talk about the case between themselves?
We tell them that unless all 12 are together, they're not to discuss the case or any aspect of it.
And I have one other question. Why do you prefer to have 12 on your civil jury?
Well, there's a wonderful article that's going to be coming out sometime soon, written by Judge Lee Rosenthal from Houston. And it tends to even out what can be an unbalanced jury. It's kind of like, you know, it's not a matter of too many cooks spoiling the broth. It's more like the more minds, the better. The more reasoned the jury or verdict is likely to be. And if you'll give me your name, I'll make sure you get a draft. The article's not going to be out for a while yet, but she sent it to me a couple of weeks ago to review.
Judge, that part of the literature suggests, and the research that we've done suggests, that the more jurors you have, the more likely you will get a diverse jury. The federal courts went down to 6. There were a lot of just plain white, all white men serving on juries, and you didn't get as diverse of a panel as you had as well. That was one claim. The other is that, in favor of it, is that there's so few jury trials and it's such a wonderful experience. Citizens, about citizenship in our justice system, our Constitution, why don't we make it more available for people? It doesn't cost that much. You're paying them $16 a day with nothing. And all the courtrooms I've ever seen have 12 chairs in it. So why has 6 or 8 become the magical number?
And of course, the answer to that is that the minimum, at least in the federal courts, is 6. And most people put 8 on just so if you lose 1 or 2 somewhere along the way, you can still have a legitimate verdict without having to get the agreement of the parties to a lesser number. Yes.
I have a question about the deliberation.
The deliberation?
Yeah, earlier you said that you guys were ranging from 0 to 350 and everywhere in between. How long did you guys deliberate, and how difficult was it was it even pushy? How difficult was it to get to a
This was a question for the jurors in the case and how you came to where you landed between 0 and $350,000.
I think the first thing that we did was write down an amount in our head where we thought we should be. And that's where we took a poll. We found that median and just where we're like, okay, so we were all okay with discussing who put what amount. So we all discussed with each other what our thinking was behind what amount we put. And if we were okay with flexing with that. I know with our case, we had one gentleman that didn't sign because he said that she shouldn't have received anything. And I can understand his thinking behind that because that's his background as well. So, I mean, yeah.
I think we deliberated for 3 hours, Yeah, I think it was 3 hours. And I was kind of on that end too, where I didn't think there should be anything, but the defending attorney made a really good case saying, you know, I'm not saying not award her anything, but not to the full amount during his closing argument. So that was helpful to us once we deliberated, is that the defending attorney came back and said, you know, here's what I would award. So that was helpful, especially knowing how much was paid to the doctors that testified in the trial. I also want to add, going back to what Steve said, I dreaded when I got that summons in the mail. I had been called 3 different times. And I just dread it. And it was the first time I'd actually been called, first time I'd ever stepped in a courtroom. And I have to say that I believe it's all of our civic duty. And when I went back to work after that 4 days, I was like the star of the office because everyone wanted to know about how was jury duty. And I said, I think everybody should experience it.
Hear, hear.
Yeah, it was not as dreadful as I thought it would be. And I am one to, you know, Judge Torrance was amazing. His clerks were amazing. It was a really good experience. And to know that I was able to, you know, as Judge Torrance had told us in the beginning when it was 55 of us, you know, this is your civic duty. We're the only country that allows the community to come together to make a decision. So that actually did it in for me. And then actually sitting there for 4 days, it was definitely a rewarding experience. I just wanted to share that.
Jurors, when you were considering the amount to award for damages, how much did you consider the ability to pay or whether insurance was going to pick up the tab?
Yeah, we were told not to consider insurance. I think a lot of the medical at the beginning, there was an ER visit after the accident happened, and then there were some visits with the psychologist afterwards, but we were told not to consider insurance.
Well, and I'd like to. So that came into play, especially since it was the defendant was a school district, and so there was lots of fear of, well, if we award too much money, they're going to have to cancel a program, and that, to kind of go off your question as well, I don't know if it's possible to set, even before we deliberate, what you can and can't do. We had people that wanted to, can we make them do community service? Can we make them do this? And we were like, I don't think so. But so, I mean, and just like that, I mean, I won't say we were all over the board. We were much more probably in a confined area and on the amount that was awarded. But yeah, initially that was the fear, was, oh my gosh, if we do this, then what about the kids? And that was a big concern to several on the jury.
Judge Mark, can I ask a quick question of the 4 of you here? I'm always curious about this. To what degree, if any, did you feel like your time was unfairly, unreasonably wasted?
Great
Did you feel like you were abused? And then, abuse is the strong word, but did you feel like your time was wasted?
I never felt that way.
What about repetitious questions? What about hearing the same thing over and over?
There was a time, yeah.
Did you have any fond memories of that?
I think some of the lawyers did drag out some of the testimony a little long during the process, but I guess I want to say too, but when we were in the deliberation though, I mean, I felt like some of the people just wanted to get out of there. They felt they were here for too long and let's just pick a number and get out of here. But I think it's very important that, you know, everybody knows how important the process is and you have to think about it and, you know, make the right decision, and whether it takes all day, hours, you know, but I guess that's all my opinion.
There's a question back here.
Oh, just a quick question on the personal injury case. I think you guys were saying that at some level you were thinking, you know, gosh, I don't really want to award anything, but the defense counsels, you know, said don't award anything, but if you do, you might go here. If that hadn't happened, if it was just don't award anything, Do you think you would have stuck to your guns on zero damages at that point? Or I'm just curious as to what your feeling was.
I know for me, I was on the lower end, but I did not choose zero because I if I was in that same situation, I would have. I try and just think and put myself in their shoes and be like, if this was going to be happening to me, where do I feel I should be compensated, and where would I be? Because I don't want to take into effect of what opinions are at that point when it comes to, well, this is what we think that they should be paid, but it's more of where I stand and if I was in that situation.
Well, and for context, Fred, tell me if I'm wrong here, Dana Harris defended your case, and Dana's closing argument comment about, we think you should return a verdict for, X amount of dollars. I think the term he used was something like some gas money and a ham sandwich, maybe. give her a little bit of something. I'm joking, but I mean, his number was low, as I recall.
He actually went down from his opening statement.
Yeah, he did.
I thought that took a lot of nerve.
Yes, and there's a mic behind you.
I have two questions. One, was there any particular part that was more interesting or more boring than the other, like opening versus closing versus cross and direct examination? And then the other one is that when the people that were thinking zero, from what I understand from what you guys talked about the case, the primary issue was the head injury because of the gap, but there were other injuries besides that. So were you guys questioning even those initial, to even be thinking about zero, questioning the initial ER visit and the other treatment that wasn't directly related to the head injury?
So when it came to the initial doctor's visit or the ER visit, when a concussion happens, and whenever they asked if anybody had a concussion, when they asked all 55 of us, I said that I did because I've had one, but it was a sports accident. One of the first things that I remember, because I didn't go to the ER whenever I had mine, I went to my eye doctor because I lost my vision because I couldn't see correct. Like everything was all blurry. For me, the first thing that he said, you might have a slight concussion if this is, and he was like, just to be on the safe side, don't go to sleep. That's one of those things that you hear. If you ask anybody, like almost anybody, what is the first thing somebody will tell you if you have a concussion? Don't go to sleep. Don't fall asleep for a while because of the underlying causes of that. And I think that's, that.
Guys, I think it's time for us to close it down. One more question.
In the TBI, the traumatic brain injury case, was there any imaging presented to you, like SPECT or other neuroimaging that you put up on a screen where you could see an injury? And had that been presented to you, do you believe that would have changed your perception of seeing a person that isn't obviously injured, but yet the technology can show that injury? That any impact on it?
May I?
I don't think so with me. I don't know if you can hear me or not. I didn't feel like there was the arguments that the plaintiff's attorney, even if we had seen just what she had gone through because she hadn't seen really a medical doctor besides the ER visit. And some of the evidence that was presented were things that I think were probably natural, that would happen during a natural process of aging or what have you. So I don't think I would have changed my decision if I'd seen an actual image of the brain.
I feel like if she may have been younger and if we had something to go off of,
as of a healthy brain compared to what hers is showing compared to somebody that does have, that is like proven that they do have an injury. I feel like if I were to see the difference between all of them, I feel like it may have moved me.
Or the gaps in treatment. There were a lot of gaps in treatment.
There was a lot of gaps in treatment.
All right, well, thank you very much. First, I want to Judge Martin, thank you, Amy, thank you for coming. Thank you, Mr. Slow, Mr. Williams, Judge Torrance, and all the jurors for being here and sharing these experiences. And look forward to coming here for another one in 6 months or a year, however soon y'all want to do another one. It's been great fun, and thank you all for coming and participating. And thank you for your service.